हेलो फ्रेंड्स, वेलकम टू आयुष्याला। आप सभी लोग हिजाब कंट्रोवर्सी के बारे में तो जानते ही होंगे, जो काफी दिनों से न्यूज में चल रही है। लाइक कर्नाटका हिजाब कंट्रोवर्सी, व्हाई मोदी गवर्नमेंट शुड सीरियसली थिंक अबाउट यूनिफॉर्म सिविल कोड। इसके अलावा उत्तराखंड के सीएम पुष्कर सिंह धामी ने उत्तराखंड के लोगों को अपने स्टेट में यूनिफॉर्म सिविल कोड को इम्प्लीमेंट करने का प्रॉमिस किया है। दोनों ही न्यूज के चलते यूसीसी पर डिबेट फिर से शुरू हो गया है। So we are going to have a detailed analysis of the Uniform Civil Code in India, which is going to be a very important topic in the Civil Service Examination 2022. Hello friends, welcome to Ayashala. My name is Nitin Galot and let us start the topic. The civil laws. The civil laws can be categorized into four different branches: tort, contracts, property, family. Here, the Uniform Civil Code in India is a proposal to replace the personal laws that are based on religious customs with a common set which will govern every citizen in India. Here, the UCC is a law which is distinguished from other civil laws which are related to tort and contract. If we talk about the personal laws, they are going to be related to the marriage, divorce, maintenance, adoption of child, and the property laws like succession and inheritance of the property. Considering the Uniform Civil Code in India, it is enshrined as a directive principle of state policy in Part 4 of the Constitution of India. It is mentioned in Article 44 as the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. First, let us see the historical background of the unification of the civil laws in India. It was during the British rule that the codification of laws can be traced. It was in the pre-independence India that the Britishers introduced Lexi Loci report, which proposed the codification of laws related to crimes, evidences, and contract. However, they were not extended to the personal laws of the Hindus and Muslim communities, as both the communities were left to be governed by their religious scriptures and customs. However, later on, it was also extended to the Parsis community. But few reforms were indeed taken up by the British during that time. They were related to the personal affairs like the Hindu Widow Remarriage Act, Married Women's Property Act of 1923, and the Hindu Inheritance Removal of Disabilities Act 1928. But such acts were not extended to other communities like Muslim because the Britishers faced stiff opposition from the conservative segment of the society who wanted to follow the Sharia law. Later on in 1920s, the All India Women Conference started demanding a uniform civil code. It was aimed to replace the existing personal laws. They argued for its implementation based on the promises which were made in the Karachi Congress resolution, in which the women were guaranteed to have gender equality. Another law which was passed later on in 1930s was a Deshmukh Bill, which was also known as the Hindu Women's Right to Property Act. But this act faced a lot of criticisms from various sections of the society. As a result of it, the Britishers constituted a committee known as the Hindu Law Committee under the chairmanship of B.N. Rao. The committee was once again revived in 1944 and it uh, proposed various recommendations. One of the recommendation was related to the implementation of uniform civil code in India, and it also provided a draft Hindu code bill for unification of various personal laws related to marriage, succession, maintenance, divorce, adoption, and other aspects of the Hindu society. It was in the post-independence India, after the constitution of the Constituent Assembly of India, that the report given by B.N. Rao Committee was widely discussed. It was in 1948 to 1951 that the B.R. Ambedkar and other prominent member of the Constituent Assembly like Jawaharlal Nehru argued for the implementation of the Uniform Civil Code in India. They argued for its incorporation in the Constitution of India. B.R. Ambedkar, in this regard, said that uniform civil code is desirable for the movement. Uniform civil code is desirable, but for the movement, it should remain voluntary. So, a uniform civil code was also given support by women member of the society and other sections of the society. As a result of those efforts, it was added into the directive principle of state policy of the Constitution of India. Apart from this, simultaneously, Dr. B.R. Ambedkar, who was also the then law minister, introduced a draft Hindu code bill in the parliament, but it was widely objected by various lawmakers and it was defeated ultimately in the parliament. As a result of this, Ambedkar resigned from the cabinet in 1951. But things continued as we discussed earlier. In the 1951 to 1954 period, the debate over uniform civil code once again arose, and it was done in the backdrop of the first general elections which were held in 1951, after which the first government of India was constituted and the first prime minister of India, Shri Jawaharlal Nehru, argued for the implementation of the uniform civil code as well as the Hindu code bill. But due to certain reasons, the Hindu code bill was split into four different laws, which were the Hindu Marriage Act, Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Hindu Adoption and Maintenance Act. They were introduced in the parliament and were ultimately passed by the parliament. Further, there were objections which were received from different sections of the society. After few months, another law was enacted which was called as the Special Marriage Act, which allowed the people to solemnize their marriage based upon secular grounds, not upon based upon the religious elements. The debate over uniform civil code in India then once again came into the news during the Shah Bano case, in which the Shah Bano wanted to have the maintenance from her husband who had divorced her through triple talaq. The case increased the tension between liberal section of the society who argued for the uniform civil code. However, the other section of the society which included the orthodox elements objected the uniform civil code implementation in India because they perceived it as a threat to their freedom of religion, and they wanted to defend their personal affairs based upon the religious scriptures. For example, Muslim wanted their personal affairs to be governed by the Muslim personal laws or the Sharia law. But the Supreme Court of India ruled in favor of Shah Bano in 1985, who was denied the maintenance by her husband under the Muslim personal laws, which debarred a woman from getting the maintenance or alimony from her husband. The, the things became more volatile when the then government of India enacted the Muslim Women's Protection of Rights on Divorce, which made a section 125 of the Criminal Procedure Code inapplicable to the Muslim woman. First, let us see the argument in favor of Uniform Civil Code in India. Help in the simplification of the personal laws. As we know that India is a multicultural society, multi-ethnic society, and the different communities have their different personal laws. So such a multiplicity of laws can be simplified with the enactment of a unified civil code. And further, it can be said that it can lead to the protection of the fundamental rights as the when any personal law which is found discriminatory in nature and it results in unequal treatment of an individual or some section of the society, and if they are found to be violative of the fundamental rights like right to equality or right to life, then they can be put to the judicial review and can be declared unconstitutional if they are found contravening the fundamental rights. It can help in fulfilling the principle of social justice as has been enshrined in the preamble of India. So the fundamental rights are mainly related to an individual. However, when uh, these fundamental rights are protected for a large group of people or a section of society, it will lead to the social justice. Uniform Civil Code in India can help in promoting the ideal of secularism. It's because secularism is related to regulating the affairs which are between a person to person. So the affairs like marriage, divorce, and other aspects are secular in nature. They are not essential part of a religious practice. So they are considered to be secular in nature, and any secular aspect can be governed by the state. So it will promote the ideal of secularism. The UCC has a constitutional backing in case of India. It is enshrined in Article 44 that the state is empowered to establish uniform civil code across the territory of India. Also, various key figures of India has supported the cause of implementation of uniform civil code in India. For example, ex-president APJ Abdul Kalam once supported the need of UCC, keeping in view the population of the country. In addition, India also has international obligation. In particular, India is signatory to Universal Declaration of Human Rights, and under this Article 16 mandates equality. So therefore the enactment of Uniform Civil Code in India will help India in fulfilling its international obligations. We can see that there are certain judicial observations which have given their verdict in favor of uniform civil code. For example, Muhammad Ahmad Khan versus Shah Bano case, in which the Supreme Court ruled in favor of Shah Bano. The other can be seen in case of Sarlag Mudgal case, which was given in 1905. In this case, the question on was whether a Hindu husband married under the Hindu law after embracing Islam can solemnize the second marriage In this case, the court held that a Hindu marriage solemnized under the Hindu law can only be dissolved on any of the grounds specified under the Hindu Marriage Act 1955. Conversion to Islam and marrying again would not by itself dissolve the Hindu marriage under the Act, and thus a second marriage solemnized after converting to Islam would be an offence under Section 49(4) of the Indian Penal Code. And third case which can be seen is the Shaira Bano case of 2017, in which the Supreme Court declared the triple talaq as unconstitutional in nature, therefore initiating a new era where a uniform civil code of India can be implemented. Last but not the least, UCC is already present in some parts of India. For example, Goa is the only state where a uniform civil code, which is known as the Goa family law, is found. It was originally started by the as Portuguese civil code, but it has continued to be implemented even after its annexation in 1961. But the uniform civil code also face certain kind of problems. It has been objected on number of grounds, or there are certain limitations to it. For example, it is very difficult to preserve the diversity of personal laws because there are many communities and each community has their different kind of personal law, and simultaneously protecting the fundamental rights of individual. It demands preserving the diversity of personal laws that are prevalent in India, but at the same time, it demands to ensure that the personal lives do not contradict the fundamental rights which are guaranteed under the Constitution of India. Secondly, the challenge can be of communal politics. Since time and again, it is due to the absence of consensus on uniform civil code across the Indian society that it has been politicized. For example, Muslim community feel that under the guise of uniform civil code, the Hindu law may be imposed upon them. Apart from these two aspects, there are certain constitutional bottlenecks in the implementation of UCC. If we see, Article 25 includes essential religious practices, which forms the part of the religions. So this element has not been defined by the constitutions, and even after 70 years of independence, it has not been defined by the judiciary of in India. Whether such personal laws comes into the domain of essential religious practices is still to be decided. Second aspect into this is that whether such personal laws which are based upon the religious scriptures can be scrutinized under Article 33, or we can say can they be subjected to the judicial review. It is because the personal laws formed by the religious bodies does not come under the definition of the laws which are mentioned under Article 13 of the Constitution of India. Thus, judiciary is not empowered to declare them void or null if they contravene Part 3 of the Constitution of India, which is fundamental rights. Fourth, we can say it can be a threat to territorial integrity because in addition to them, there are certain areas in India which have been given special status. For example, the sixth schedule of the Constitution of India provides certain protection to the socio and cultural practices of the communities which are living in certain states of India. For example, the tribal laws in fact protect matriarchal systems of family organization. Some of these also preserves provisions which are not in the interest of women. Other than this, there is a special category under Article 371A to 371I which are related to different states of India, one of which is Nagaland, in which the Constitution of India allows the local people to govern themselves by their own socio and cultural customs. So it can be a challenge in implementation of Uniform Civil Code of India in those areas. So it can lead to threat to territorial integrity because most of such states are present on the border region of India and thus can be a threat to territorial integrity. Last but not the least, there is a lack of consensus on nature of Uniform Civil Code. There are different sections. One who believe that there should be a blend of all the personal laws, or there is a section which argues for a totally new law which is adherent to the constitutional mandate. So there is a lack of clear understanding and consensus over how we can approach the implementation of Uniform Civil Code or the codification. If we see the way ahead, we can say first of all, there is a requirement of consensus building in India. It can be done by settling the debate which has been there between the secularism and the freedom of religion in India. Educate steps should be taken in order uh, to fully educate the people about what is the meaning of secularism and what constitutes the freedom of religion in India. For example, secularism means a state should not intervene in the religious affairs, and that religious affair should be restricted to the individual faith, which means the relation of an individual with the God. Secularism allows the state to intervene in the matters which are related to the person. So the personal affairs like marriage, divorce, maintenance, and adoption, such kind of affairs are related to person. They are secular in nature. They should not form the part of religious aspect. Therefore, the state is empowered to regulate them. It will not result in the violation of the freedom of religion of a person or a community because they are secular in nature. Simultaneously, there are also some judicial precedents with respect to the implementation of the Uniform Civil Code in India. For example, in Shaira Bano case, the Supreme Court of India very well defined that triple talaq does not form the part of essential religious practice, and as the law which provided uh, the base for the triple talaq was a law before the commencement of the Constitution of India, therefore it comes under Article 13 and it was subjected to the judicial review. And when the Supreme Court of India found that the triple talaq practice is contravening the Article 14, which is right to equality, therefore it was subjected to the manifest arbitrariness test, under which it was declared null and void or unconstitutional in nature. For the implementation of Uniform Civil Code in India, the Law Commission of India institutionalized a consultation paper on reform of family laws. Under this, it gave four prominent recommendations, in which the first one is related to that the legislature should first consider guaranteeing equality within communities between man and woman. rather than equality between communities. It will help in resolving the differences within the personal laws which are meaningful and those which can be preserved, and those personal laws which leads to inequality can easily be weeded out to the greatest possible extent. Okay, the first of all, the step for doing so, there should be a codification of the personal laws by the parliament. In this way, the inequalities will be added into the codified forms, and such codified laws can be remedied by the amendments in the future. In addition, by virtue of being enacted as the law, such codified laws will be subjected to the judicial review under Article 13. And if there is any crystallization of prejudice or stereotype into this, then they can be directly taken into the court, and if they are found contravening the fundamental right of an individual or a community, they can be declared null and void by the Supreme Court or the High Court of India. For example, the codified personal laws could be challenged into the court for contravening article like Article 14, which mandates right to equality to the people of India. At last, it can be said that there is a need to start the process of the codification of the personal laws with institutionalized discussion on this topic as soon as possible.